From the big, beautiful bill to the big, beautiful lawsuit, suppressors certainly seem to have a lot of steam behind them on the national stage. Even here in California, we've got a challenge to California state law in SanchezVBonta. The question is, should Californians really be paying attention to and care about the suppressor issue? Let's talk about it. Hey everybody, welcome back to the channel today. We've got big beautiful bills, big beautiful lawsuits on the mind, overall talking about suppressors and whether or not Californians should really even care what's going on at the federal level. To walk us through all of these pieces of the puzzle and hopefully tie them together for us is CRPA President. That of course is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, fellas. Thanks for having me.
Yeah, absolutely. And guys, as always, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms, getting the information out there as we continue to move the Second Amendment ball rolling forward here in California. We want to make sure that everybody's getting this information. It's also a great way for you to directly contribute to Second Amendment litigation and legislative efforts here in the state of California. So go ahead, like, share, subscribe, throw some comments down in the section below, ask questions, cheer us on, anything. It really all helps. Might as well start at the federal level here with the big, beautiful bill. Of course, within that was the Hearing Protection Act. I don't think we need to go through too much other than the highlights on this. You essentially had an opportunity to remove suppressors, short-barreled rifles, short-barrel shotguns from the NFA. That, of course, is what was imposing the $200 tax on the purchase of those products, as well as a registration. We could have had it all. I mean, technically, you know, with the way the big beautiful bill went down, reducing that tax to $0, you know, is technically a good thing. However, it does seem to be on the national level a little bit of a disappointment because we could have removed them from the NFA and also the registration portion of that altogether. But where the legislature falls short, I guess the firearms community comes back and says maybe we can get the rest of what we want through the courts. That, of course, is the big, beautiful lawsuit that was filed by Gun Owners of America. Thank the Lord. Jacob, if you could actually pull this up, I wanted to read from it. It reads like this. Enacted in 1934, the National Firearms Act, NFA, is premised on Congress's taxing power. The act imposed a $200 tax, approximately $5,000 in today's dollars. Remember that. That might be a little important later. On the manufacture and transfer of particular classes of firearms. The NFA's authors left no doubt that the NFA was an exercise of taxing power, and the Supreme Court upheld it on this basis. Remember that. That's going to be important later. This has been the uncontroversial understanding of the courts and commentators for nearly a century, but the NFA no longer imposes any tax on the vast majority of firearms it purports to regulate. The One Big Beautiful Bill Act, which Congress and the President enacted on July 4th, 2025, zeroes the manufacture and transfer tax on nearly all NFA-regulated firearms. That means the constitutional foundation on which the NFA rested has dissolved, and the NFA cannot be upheld under any other Article 1 power. With respect to the untaxed firearms, the act is now unconstitutional. The One Big Beautiful Bill Act left undisturbed the NFA's registration requirements and restrictions on manufacture and transfer, which for most NFA firearms now lack any accompanying exercise of Congress's taxing power. Plaintiffs are individuals and organizations who are burdened by the NFA's regulatory requirements pertaining to untaxed firearms. Plaintiffs seek an order declaring that the NFA is unconstitutional with respect to untaxed firearms it purports to regulate and enjoining enforcement of the unconstitutional provisions. So, Chuck, I'm curious, is it really as simple as this? You want to tax these firearms, so you create a registry to ensure that everyone purchasing them is being taxed. If then you take away the tax, that makes the registration portion unconstitutional. Is it really as simple as that?
Not exactly, but almost. Remember, the NFA, when it was originally passed, they didn't think, the Solicitor General of the United States said, we can't make this just a crime to possess these things because of the Second Amendment. They had a different perspective back then. And so they made it a tax bill. And then to collect the tax, you had to register the firearm. The Registration Act itself was designed to collect the tax but there still is a separate registration aspect. So if you think about it, this kind of becomes like a so-called assault weapon, a semi-automatic ban, where you can keep the firearm if it was registered. You can sometimes get a permit to buy one of these semi-automatics that are otherwise banned. And that's why we have multiple challenges against multiple semi-auto bans across the country, because they're basically banning that particular firearm or red taping it often to death. So that's what the NFA did. Now, without the tax as the justification for the registration, it's simply a registration requirement on a particular product. So the question becomes then, under Bruen, is there some historical justification, some historical analog law that suggests that the founding fathers would have tolerated essentially banning? This is really a ban. It's a ban unless it's registered. That's what it is. So is there a historical law that would allow you to ban suppressors or short barrels unless they're registered? And there's a good argument for that. It's the same basic argument that's been made in other hardware cases, whether it's semi-autos or suppressors or magazines. All of this is a way to try and limit the hardware that people can get access to. But it's going to be that Bruen test now. Is this firearms ban? Is this suppressor ban unless it's registered? Does it pass the Bruen test? I don't think it does.
Well, and then even further, you kind of gotta ask the question: is an underlying purpose something that can be, sort of categorized as a historical analog? Jacob, if you could pull this one up, I thought about just sort of trying to understand what the government has thought about the NFA. And if you go to the ATF website, it reads like this. While the NFA was enacted by Congress as an exercise of its authority to tax, the NFA had an underlying purpose unrelated to revenue collection. As the legislative history of the law discloses, its underlying purpose was to curtail, if not prohibit, transactions in NFA firearms. Congress found these firearms to pose a significant crime problem because of their frequent use in crime, particularly the gangland crimes of that era, such as the St. Valentine's Day Massacre. The $200 making and transfer tax on most NFA firearms were considered quite severe and adequate to carry out Congress's purpose to discourage or eliminate transactions in these firearms. The $200 tax has not changed since 1934. So even if we remember what the big beautiful lawsuit stated, which was that $200 tax back then was equivalent to about a $5,000 tax today, sort of seems to substantiate what the ATF is saying here, which is that the legislature had an underlying purpose, and it was to really ban the sale of these items for those at the time. Now, of course, as time goes on, the actual value of money changes. $200 to us now is a lot different than $200 back then. I guess my question to you, Chuck, is, does an argument like this, well, first of all, I mean, we can assume that this argument is going to be used in court. And I guess you can confirm whether you think the same thing. But if it is, does it hold any water in the courtroom?
Well, I mean, it's certainly accurate that the reason that they passed the NFA was in response to, primarily Prohibition era gangland, gangs that were very violent. And the key thing that the NFA banned was full auto. Remember that. These are other kind of related, they characterized them as criminals' preference. But nowadays, leaving the full auto issue aside for a minute, suppressors are not silencers. Suppressors are not like some kind of an assassin's tool. They are a hearing protection device, and they've evolved into a very sophisticated piece of technology, of sound suppression technology, that is not a criminal's choice. They are in use and would be in much more use and in much more demand if you didn't have to go through this rigmarole. It was never really the tax, I think, that stopped people from from pursuing a suppressor. This is what gun trusts are all about. I mean, there's lots of suppressors in civilian hands, despite the $200 tax. The hard part is doing that registration paperwork and getting approved. So, yeah, I mean, it's true that the law originally was designed to try and get specific types of firearms out of, to ban them because they were so uh, often used by gangs and criminals. But that's not a rationale anymore. Uh, and that's the same argument again that they've made in the semi-auto cases. Oh, this is a weapon of war. The AR is a weapon of war, even if it's semi-automatic. I mean, it's the same analysis that applies regardless of what the government's motivation was. We challenge criminal laws all the time, whether there's a tax on the registration or not. And in fact, there kind of is. They always charge a fee to register your semi-auto. So it's very much akin to a lot of the cases that are already making their way through the courts.
But there certainly has been a lot of steam created for suppressors on the federal level, having to do with the Hearing Protection Act in the Big Beautiful Bill, a huge grassroots effort while that was going through the process. And again, I know that we didn't necessarily get what we wanted on the federal level, but I feel like that does put a lot of that steam now into the Big Beautiful lawsuit here filed by Gun Owners of America. And it's going to have the support of a lot of people around the nation. But for that matter, let's go ahead and tie that now into
CRPA will certainly be helping out and filing amicus briefs in that lawsuit. So will the Second Amendment Law Center. It's high time for suppressors to be decriminalized and to not require this registration. You'll still have to go through a background check probably to buy one, but that doesn't mean you have to have it registered like a fully like a AR-15 or another semi-automatic.
Right, that support will absolutely be there, which kind of feeds into the answer to the question of should Californians really care about this? I think the answer ends up being absolutely yes, and it's even further substantiated by litigation that we already have in the state, which is a little bit of a newer one. Chuck, before we jump into this, though, I did want to read from SanchezVBonta. So, Jacob, if you could actually pull this one up really quick from SanchezVBonta, it reads like this. Firearms outfitted with suppressors facilitate armed self-defense by reducing, but by no means silencing, the sound produced by any firearm, and therefore offering several safety-enhancing benefits to firearms users and those around them. Suppressed firearms are therefore protected by the plain text of the Constitution, and there is no historical tradition that justifies California's law banning suppressors. Indeed, in another case relied on by the state, the federal government has now conceded that suppressors are entitled to Second Amendment protection. As a result, the federal government has insisted a ban on the possession of suppressors, like California's ban at issue here, would be unconstitutional. That view is correct and commanded by any fair application of the Supreme Court's Second Amendment jurisprudence. California's suppressor ban is unconstitutional. So, Chuck, this is a relatively new one to CRPA. Can you go ahead and just sort of summarize this? We have made one video on this, guys, if you want to go back and take a look at it a little bit more in depth. But Chuck, for purpose today, can you go ahead and just recap this for us? How did CRPA get into this case? Where is it at in the court system now, and what is the complaint?
Well, it's in the Ninth Circuit, and the lawsuit challenges California's ban on suppressors. Interesting way this case evolved. It was filed by an individual without an attorney, who then lost in the trial court, took it up on appeal to the Ninth Circuit, filed a brief. The Ninth Circuit said, look, this is a serious issue. And they kind of put out the word for law firms to basically drop in and help this plaintiff. So my firm did, and so did Cooper and Kirk, another law firm. And so we're working together to try and try and win this case. But to be honest, like full auto challenges, Bruen is still being misinterpreted and misapplied all over the place. And when you bring a full auto challenge or even a suppressor challenge, even though they're much easier to explain how they're about hearing, not making a gun assassin desirable. those are sort of issues that could wait a little bit. I mean, we're working with the Suppressor Association, and there's lawsuits in several other states challenging state suppressor laws, and they really do we want to push that, but we really need to get, and this is probably a good segue into Duncan, what we'll talk about in a minute, the Duncan case. We need to get the Supreme Court to slap down some of these lower courts and force them to apply the Bruen standard faithfully. And you don't want to give them an opportunity to use some scary product as a justification for them issuing a biased opinion that upholds the law by misapplying Bruen and distorting the Supreme Court's rulings.
And that is a fair segue. Talking about Duncan, talking about the scope of how we view Second Amendment cases and how it's being misinterpreted. That is something that we're hoping, if Bruen is, or if the Supreme Court does end up taking the Duncan case, that could potentially come out of it. I did see that another extension was filed for Duncan. I know we've been looking forward to the deadline, which was supposed to be this week on the 18th, which I think is Friday, right? It's no longer that. We're pushing it into August. Can you go ahead and explain what this extension is for and the date that we're looking towards now?
Sure. Well, remember, our brief was first due about a month ago. And right around the time it was due, the Smith & Wesson case came down out of the Supreme Court, and the Ocean State Tactical Magazine ban case and the Snopes semi-auto ban case the Supreme Court declined to take them. But in so doing, there was some very good language in all three of those cases, in the dissents for granting cert and in the 9-0 unanimous verdict against Mexico in the Smith & Wesson case, where one of the liberal justices wrote an opinion that had some great language in there that was helpful to the Duncan case and any other Second Amendment case. So we waited to try and get that, got our first extension to get that language into our brief. But then as we got ready to do this, the Supreme Court doesn't have to, it's discretionary review. They don't have to take the case. You need 4 votes to take it, 5 votes to win it. So we are now reaching out to try and coordinate an amicus brief campaign, that is friends of the court parties, that will also join us in asking the Supreme Court to take this case. Now, the thing about amicus briefs in the Supreme Court on a cert petition, that's the initial request for a review, is that the amicus parties only have 7 days after you file your cert petition to file their amicus brief. And this is a fairly complicated topic. So we've been working to pull all the prestigious amicus groups, the pro-2A groups, plus government entities, including the Trump administration and attorneys general across the country, to join us in asking the Supreme Court to take this case. And they need more time to get approved to join us in requesting the Supreme Court to take the case, and then also to write the brief. They're not going to be able to do it in 7 days. So we had to get another extension to August 18th, primarily to give all these amicus parties time to get their brief ready, so they wouldn't have to just do it in 7 days.
All in the name of making Duncan more appealing to the Supreme Court, more of a ripe case for them to take it and to rule in a way where we can look through the lens of Bruen for a lot of other pieces of 2A litigation moving forward. So, Chuck, overall here, I'm curious, what are your final thoughts as far as the suppressors are concerned? You've got some puzzle pieces. We tried to put them together a little bit today. You've got the big, beautiful bill leading into the big, beautiful lawsuit. You've also got SanchezVBonta here. Are these going to end up feeding off of each other as we see precedent end up being put into litigation, as we've seen so many other times? What does these correlated to each other, what does it look like moving down the road?
The dynamics of this have not changed. It's still about faithfully applying the Bruen methodology. Is it covered by the text of the Second Amendment itself? That's not a big hard hurdle to overcome. If it's bearable, it's covered. And not only that, all the conduct related to that, going to the range, hunting, target shooting, self-defense, all of that stuff is part of the Second Amendment's protections, the language of the Second Amendment. Then if it is, most of the time it will be, then the question is there a historical analog, some historical law which would signal that the founding fathers would have tolerated a modern day law because they're similar. That has been distorted by every court. They try and say that a magazine is not an arm, or a fully automatic is not an arm, or a suppressor is not an arm. So it's not covered on that first by the Second Amendment to begin with. That's completely wrong, completely misreading, completely misapplying Bruen. And then they reach out for these skimpy, a Bowie knife law justifies a modern day semi-auto ban. The analogies there are not what the Supreme Court has said is required in order to justify a modern day law. Whether it happens in Duncan or Sanchez or the case, the NFA case that GOA just filed, the Supreme Court needs to take one of these cases and apply the methodology faithfully and explain to the lower courts that you're getting it wrong, you're twisting our words, you're biased in many cases, and now you got to get it right. We're telling you to get it right. These inferior courts are not following the Supreme Court's mandate, and the Supreme Court should stop letting them get away with it and tell them, and they can do that very emphatically by accepting the Duncan case. And that's what because the Duncan case will give them the opportunity to explain in kindergarten terms for some of these lower courts what the Bruen decision means and how it's supposed to be applied. So Bruen is now in the spotlight. It's one of the probably the furthest case along, and it's been tried twice. It's a package that's exactly what the Supreme Court is looking for. It's been tried in the trial court twice. It's been up on appeal twice. There was expert testimony. Everything was developed. This was not a preliminary injunction. It was a judgment. So it's a final decision from an en banc panel in the Ninth Circuit after being tried twice in the trial court. Fully developed record. This is, and many of the entities that are joining us recognize this is the case that's the package the way the Supreme Court likes. So they have every reason to take it.
Yeah, so a lot to look forward to, a lot of good arguments coming down the pipe here at a time where there's a lot of steam behind the suppressor movement, and at a time where there is some national frustration egging the Supreme Court to take on a Second Amendment case. So certainly an exciting time to be a part of this. CRPA lawsuit might be the next one that does it up at the Supreme Court in Duncan. Chuck, I want to thank you. Keep up the good work. Thanks for being on with us today and sharing the wisdom. I appreciate it.
Thank you to everybody who's donating to the CRPA to help support that Duncan case and all our other cases. We're just scratching the surface here with the cases we're talking about today. CRPA has an awful lot going on. So please join us, support us, be a part of history, because it is a historic time for the Second Amendment.
Absolutely. And guys, as always, if you like this content, you want to continue to see more, you want to continue to see those pro-Second Amendment lawsuits and the pro-Second Amendment fight up in Sacramento, please be sure to like, share, and subscribe to the videos. It's a great way for you to directly contribute to those things. Thanks again, guys. We'll see you on the next one.